In this video, we will go over the forms MP 701, Request for Hearing and Default by Clerk, and MP 702, Court Order on Hearing for Disillusion with Minor Children. If you have any questions at all while watching this video, please contact the closest self-help law center. Either the petitioner or the respondent can fill out MP 701, Request for Hearing and Default by Clerk. This form is used to request a hearing in order to finalize your dissolution. Once the petitioner serves the respondent has 21 days to file a written response with the district clerk of court. If you are the petitioner, you have to wait until you receive a response, or if it has been more than 21 days since your spouse has been served to fill out this form. If you are the respondent in the case, then you can use this form as long as you have filed your response with the clerk of court. On the first page of every form, you will find a caption. This caption should be identical on all your forms. On the top left, please fill out your name, your mailing address, your phone number, and your email address. Below this, check the box that reflects which party you are in the case. If you started the case, you are the petitioner. If you are responding to the case, then you are the respondent. And if you are filing jointly with someone else, you are either the petitioner or the co-petitioner. Next, fill in the judicial district number and county in which you are filing the documents. You can find this information on courts.mt.gov/locator. If you are the respondent, look at the caption on the documents that you are served with to find the information. Next, write in the name of the petitioner and respondent or co-petitioner on the appropriate lines below. Remember to always put the name of the petitioner on the first line and the respondent or co-petitioner's name on the second line. To the right, you'll see the title of the document. Above that is where your case or cause number should be written in. Please leave this line blank unless the court has already assigned a case or cause number to you. If you are the respondent, you can locate your case or cause number on the documents you were served with. The first line of the form asks you to identify yourself as the petitioner, respondent, or co-petitioner. Check the box that most accurately describes which party you are. Part 1 of this form asks for the status of the case. This part of the form is essentially asking if the respondent responded to the petition, and if they did, if both parties agree on all the issues or do not agree on all the issues. If you did receive a response, or if you are the respondent, then you will indicate that the respondent is participating and whether or not the two of you agree on everything. This is important information because it helps determine what kind of hearing you will need. If you are the petitioner and did not receive a response from your spouse and it has been more than 21 days since they were served, then they are not participating. If the respondent is not participating, then the petitioner will ask the clerk of court to enter default against the respondent, and the court could potentially grant the petitioner everything they asked for in their petition. Part 2 asks about child support. You will check who submitted child support to the court and whether it's a child support worksheet that you or your spouse did on your own or a child support order created by Child Support Enforcement Division. Under Part 3 of this form, you will inform the court on the status of your financial disclosure. Part A of Part 3 asks if the petitioner, respondent, or both spouses served a copy of their preliminary disclosure of income and expenses and proposed property distribution. If you both served this information to one another, then you can check both. But if only one of you did, then check the box of the individual who did. Next, Part B asks why these forms meet the financial dissolution requirements. You will only need to choose one reason, and it is the one that most accurately reflects your situation. Paragraph 4 of this form is where you can choose the type of hearing you are requesting. The type of hearing you will choose is dependent on how you answered Part 1. If you answered that the respondent is not participating, then you will be requesting a default hearing. However, if you are the petitioner and received a response, or if you are the respondent, then you will be requesting an uncontested or a contested hearing. If you both agree on all the issues, you will be requesting an uncontested hearing. But if you do not agree on all the issues, then a contesting hearing might be what is ordered. After you finish filling out the form, you will need to sign and date it, and then it can be filed with the district clerk of court. When filing this form, you will want to have a copy of it so you can send it to the other party. Now we will discuss how to fill out MP 702 Court Order on Hearing for Disillusion with Minor Children. When filing a request for a hearing in default by clerk, you must also file the court order on hearing for disillusion with minor children. The clerk will use this form to notify you and the other party of when your hearing to finalize your dissolution is and where it is located. When completing this form, you will fill out the caption identical to your previous filings, and the rest of the form should be left for the court to fill out.